Good morning. Today we're going to be talking about effective client screening procedures. And the majority of legal malpractice claims come from issues surrounding the attorney-client relationship. And many of these claims can be avoided if you learn to screen a prospective client before you accept representation. Now, when you're starting to practice, it may be difficult from an economic standpoint to turn a potential client down. But as you will see, deciding not to represent someone may often be the right decision in the long run. So what does an effective screening procedure look like? What it involves is asking a series of questions and getting answers to those questions to help you make a decision whether this client is going to be a right one for you. So the first thing you want to look at is what is the legal matter for which representation is being sought. Is the matter something that is within your area of expertise? Under the rules of professional responsibility, you have an obligation to your client to have the necessary knowledge, skill, and expertise of the law at issue. If you don't have that experience and skill, then you shouldn't be handling the matter. What you can do is refer the matter to an attorney who does have that skill, or you might consider associating with someone who does. Another thing you might want to consider is whether you have the time and staffing to handle the matter at issue. Are there immediate deadlines that have to be met? And if so, are you going to be willing and able to meet those deadlines? And secondly, it's important for you to consider whether there are potential conflicts of interest. An attorney owes every client a duty of loyalty, independent judgment, and confidentiality. Therefore, you have to consider whether there is a conflict. If a conflict does exist, can it be waived? And if it can be waived, it must be done so by written consent. You must obtain a conflict waiver. Also, consider whether there be situations where representation would be inappropriate, even though the parties have consented to your representation, because there are situations where representation would not be appropriate, even where the clients have consented. So we've looked at questions regarding what the legal matter is for which representation is sought. The other major category that you want to get answers to questions concerns the client himself. You should learn all you can about the prospective client. For example, what are the client's expectations? Does the client already have an expectation regarding the dollar value of the case? What about the length of time that it may take to conclude the matter? Note that if your client has unreasonable expectations, it may impact your ability to handle the matter appropriately. For example, the client may be difficult to control as a witness. The client may be dissatisfied regardless of the outcome if they already have preconceived notions of what the outcome should be. So the best rule of thumb is to communicate openly with your client from the beginning of representation through the life of the file. This will help keep the client informed and will also keep expectations in check. You should know that legal malpractice claims and ethics complaints are filed in response to an attorney's attempt to collect unpaid legal fees. So it is in your best interest to determine prior to the beginning of representation whether the potential client can afford your services. This is something, the business arrangement, is something that you must discuss with the client prior to representation. The discussion should include your ability to withdraw from representation for non-payment of fees. This is often something that clients don't realize that this is an option the attorney has available to him or herself. The business relationship should be put in writing. It should include the scope of representation, what is it that you've been retained to do, and it should include the specifics of the fee arrangement. You might also consider requesting a retainer from the client. Consider charging interest for overdue accounts, and you should also bill monthly and stay on top of your account receivables. If you determine that the client is unable to pay or unwilling to pay, then you should decline representation, or you may decide to handle the matter on a pro bono basis. Another area that a red flag should be raised is where a client is changing lawyers. In that event, you should proceed very cautiously, and there are many questions and avenues that need to be explored before you agree to the representation. So first, determine whether the prospective client was dissatisfied with their prior counsel, and if so, why? Can that relationship be mended? If not, why not? Has money been an issue with the prior lawyer? Does the client owe any legal fees to the lawyer? You also want to know if the client has ever been involved in a fee dispute with another lawyer. Have they consulted with other lawyers regarding this matter? And it's also important and interesting to know whether the client has been rejected by other lawyers for this matter at hand. Has the client ever made legal malpractice claims or filed an ethics complaint against another lawyer? These are all difficult questions to ask, but they are not as difficult as going through the time and expense away from your practice to deal with a legal malpractice claim or an ethics complaint, not to mention the extreme emotional toll that is taken. So be an advocate for yourself and ask the necessary questions. Important to note is that lawyers who are sued for malpractice frequently report having a bad feeling about the client from the beginning. So what is your first impression of the prospective client? Many times this is the best indicator of whether this will be a good relationship. So trust your instincts. So after you have done the screening and asked the appropriate questions, what are some other steps that you can take to further protect yourself? You can send an engagement letter. You should send an engagement letter for the client if you've decided to represent him. It should set forth the scope of the retention and the fee agreement. If you've declined to represent the client, you should send a non-engagement letter that clearly informs the client you are not representing him or her and that you have no opinion about the matter. If there's a statute of limitations at issue, that should be addressed, and you should inform him that they should seek other representation. You should send a non-engagement letter if you have referred the client to another attorney without a referral fee. And if you have referred the client to another attorney and you expect to receive a referral fee, you should send the client a letter disclosing what is required by the applicable ethics rules and obtain the client's consent if that is required by the ethics rules. So you can see you will go a long way in protecting yourself from ethics grievances and legal malpractice complaints if you put into practice an effective client screening procedure. Do all you can to learn about the client and the matter for which representation is sought. But don't forget that the best screening procedure you have is your instinct. Trust it. Thank you.